Hi, everyone. Welcome to the UCLA Tribal Legal Development Clinic's Brown Bagged Lunch series for June 26th. It's happy to see you. I hope.
Lauren, I can't hear you.
There we go. I'm sorry, I was muted. Welcome,
okay,
everyone.
And can you mute everybody but the speakers, because we can hear other people?
Or any combination of such.
There we go. That's much better. Welcome, everyone. Welcome to the UCLA Tribal Legal Development Clinic Lunch Bag, Brown Bag series. I'm Lauren Van Schilfgaarde, Director of the Tribal Legal Development Clinic, and we are very excited to have you. We hope that you are safe and that your families are safe. We're very excited to be featuring the debrief of the McGirt v. Oklahoma Supreme Court case. We were hopeful that we might have a opinion out, but it looks like we won't, which is part of an ongoing saga happening at the Supreme Court. But that doesn't mean that there isn't plenty to debrief. So with that, I'm going to turn it over to Professor Angela Riley, who is going to be helping facilitate today. Professor Riley.
Thank you, Lauren, and hi, everybody. It's wonderful to have you all here. I'm glad that you're able to join us for this wonderful conversation. We're absolutely delighted to be able to welcome Riyaz Kanji and Matthew Fletcher to our Brown Bag today. They really need no introduction. They're both leaders and luminaries in the field of federal Indian law. But let me just say a brief word about each of their bios in case you're not as familiar with them. I'll start with Riyaz Kanji is a founding member of Kanji and Katzen, the law firm, and he's the directing attorney for the firm's Ann Arbor office. He, as many of you probably know, is a leading trial and appellate litigator on behalf of Indian nations and tribes across the country. He's here today in part because he is lead counsel for the Muskogee Creek Nation in the McGirt case, which is what we're here to talk about. He also served as lead counsel for the Muskogee Nation in the predecessor case, to some extent, Carpenter v. Murphy, and he has also appeared before the Supreme Court in other cases, including United States versus Washington, and also worked on Dollar General. So he did his undergraduate degree at Harvard and his JD at Yale, and he's really one of the leaders in this field, and just also a wonderful person, an incredible human being and mentor. So we're delighted to have him. I also want to introduce Matthew Fletcher. Matthew and I have been friends for a long time, going on decades now, and as well as with his wonderful wife, Winona Single. Professor Fletcher is a professor of law at Michigan State University College of Law, and he directs the Indigenous Law and Policy Center there. He's been a visiting professor at Arizona, Michigan, Montana, and Stanford, all at the law schools. He is one of probably the strongest leader in all of Indian country in terms of his work sitting for tribal courts. The list is really impressive, working as an appellate judge for Hoopa Valley, Mashpee Wampanoag, Matchabenashuish, Pokagon Band, Nottawasepi, Rincon, and the list goes on. Matthew has been an absolute leader in this field for a long time, and his voice really permeates in terms of his work through Turtle Talk, the blog, through leading the ALI project restatement on American Indian law, writing the first and I think only casebook on tribal law, and really being a prolific scholar and having published in all the top law reviews, and just really exhaustive in terms of his work in the field. So I'm delighted to have both of them here to speak. And what I want to do, I think we agreed Matthew is going to go first, and I think we want to just really have a conversation today and give Matthew and Riyaz a chance to give us thoughts about the case, reflections on Indian law before the Roberts Court, if they dare, predictions about the case, and where we kind of see Supreme Court litigation in our field going in the coming years. So with that, I will turn it over to Matthew Fletcher. Thanks, Matt.
Well, I'm not sure. Again, I said this before, I'm not sure why I'm going first, but I will try. We were told, and I assume that if you are such an Indian law nerd as to be on a talk like this today, you probably know about the case. And that's a good thing. It shows that that is, these issues are interesting and important enough to pay attention to. I come to this case, as I said to the people before, that as a bit of a stranger. This is very much an Oklahoma-centric case. We've never had, in Michigan, where I'm from, a reservation boundaries case reach the Supreme Court, and that's probably a good thing. And we don't have the death penalty in Michigan either. And that's not at issue in the McGirt case, but it is an issue in the companion case that was argued in the last term, the Carpenter versus Murphy case. So I'm going to just jump right in and throw a few things out there. I have the first thing I would point out in relation to the older case, the Murphy case, it's a death penalty case to start out with. And I think that's a really important thing that we don't spend a lot of time thinking about. I have colleagues here at Michigan State who are leading empirical researchers on the capital punishment in the United States, particularly in places like Oklahoma and Arizona and North Carolina in particular, who were interested in this case because it's a crossover, I guess you could say, between Indian law and the work that they do, the death penalty work. And just listening to the argument in the Murphy case and also looking at some of the briefs, we're shocked that this is not a death penalty. This case, the Murphy case in particular, was never discussed as a death penalty case at oral argument, and had a weird cast of characters in signing on to amicus briefs who also didn't mention the death penalty. The Murphy case had the oil and gas industry filing an amicus brief in support of the state of Oklahoma in a death penalty case. And you might wonder why that's the case. They are very clearly concerned that if the Muskogee Creek Reservation and other reservations like it who are similarly situated in Oklahoma, if those reservations are to be considered Indian country anew, then they would be subject potentially to some tribal jurisdiction. That is probably an overblown concern, but not so overblown as to, at least for the oil and gas industry, to be interested in these cases. So that's the first point I wanted to make, is that, not so much in McGirt, but in the first case, I want to remind everybody this is a death penalty case. The second part I wanted to point out, just as a general matter, and I hope some of my students from this morning's class in Montana are on this, so they'll know what I'm talking about. It's interesting to me what kind of facts become relevant at the Supreme Court. You have amici on both sides who are tossing in bombs from both sides toward the Supreme Court. We've seen cases in Indian law cases before at the Supreme Court where the amici make some pretty outlandish representations, and I'm not limiting that to just the non-Indian or the non-tribal side, but the tribes are predisposed to go in that direction too. And as an amici, an amicus, there's an encouragement. I guess there's an effort to get the attention of the court to say, look at my amicus brief, by saying outlandish things. In this case, both in the Murphy case and in the McGirt case, although perhaps it was a little bit toned down in the McGirt case, the state itself of Oklahoma, the party to the case, made outlandish statements. And let's talk about briefly what they did in the Murphy case was to put a picture of the skyline of Tulsa in their actual brief. And the court sort of, at oral argument, brought it up. I think Justice Breyer perhaps, and sort of made a joke of it. But it was no joke. It was the epitome of dog whistle to remind the court that Tulsa is not Indian country. Look at these buildings. Indians couldn't have built these buildings. You know what to do here. And that's sort of where I'm heading with the second point is, when we're not talking about a death penalty case, it's framed as, the outsiders, the Indians, the foreigners even, and the way that we are often described, are coming to take over again. If you read news reports on both of these cases, they are, even from the reports that tend to be sympathetic to the tribal issues, they are couched in terms of, will Oklahoma become all of eastern Oklahoma become an Indian reservation and return to the control of Indian tribes? And, when a case like that is framed in that way, you can almost be sure that the court, even the ones who tend to be sympathetic or open to listening to tribal interests, will be looking for every conceivable avenue to rule against the tribe in a context like that. Now, that's an inaccurate context. The first case is a death penalty case. These cases are not about, control over the entire reservation by tribes over non-Indian people, non-members. But that the way this case is framed really is quite shocking to me. Although, it's not shocking. It's sensational, and it's completely unsurprising. This is how you win Indian law cases. You demonize Indian people, get the biggest dog whistles you can find and blast them as loud as you can at the court. And you can see that in this case, perhaps more so than any that we've seen in the last 15 or 20 years. How's that for an opening statement?
That's great. Thank you so much, Matthew. And I would now, Riyaz, we're dying to hear from you, so please take it away.
Thank you. Thank you very much, Angela. And it's a real pleasure to be here. Really appreciate the UCLA putting on this brown bag series. I want to say at the outset that I believe that this is a collaboration of the UCLA, Montana, and Michigan State Indian law programs, and those are three terrific programs. And for those of us who have been practicing for a while, it is so wonderful to see how Professors Riley and Fletcher and others have developed these terrific programs at really top-notch law schools around the country that are serving as such a outstanding pipeline for terrific students entering the field. And it's really been a marked development over the course of the last couple of decades, and we're so excited about that. And we're seeing the dividends in terms of the quality of the students who are coming into practice, and we so appreciate those efforts. And thank you for having me today. I want to start with I'm going to start with a couple of stories, and then want to share a few observations, but to the maximum extent possible, would love for this to be as much of a conversation and hear questions from those who are in the audience, and have as much of a roundtable discussion. I get tired of hearing my own voice all the time. So, but I do want to start with two stories, one historical and one present day. The historical story is this, and it's like so many of the stories we deal with, a very unhappy one. But when the members of the Creek towns in Alabama were resisting mightily, as strongly as they could, were resisting removal, and ultimately, as we all know, the federal government threw up its hands and said, "There's nothing we can do, even though we've promised you that you can remain in your sacred homelands, and let the settlers and the state militias come in to the towns." Those towns were burnt to the ground. The settlers wouldn't even wait until the Creeks gathered up their belongings to start their long forced march westward. And as they were leaving, these people saw their towns burning and gathered as many of the ashes as they could, the sacred ashes from their old talwoods. And the members of the Creek Nations carried those embers with them on the Trail of Tears. And at each night when they stopped and they built a fire, they would rekindle some of those embers so that they could have that feeling of carrying their old towns with them. And when the creek finally crossed over the border of what was to be their new treaty promised reservation, they took those remaining those embers that they carried all the way over those 2 bitter years, and below a great tree in what is now the city of Tulsa, they kindled a fire and placed those embers, and that is how they consecrated the building of their new town, Tulsa, Tulway, in the Creek language, and that is where they set about to start their new life. So when Matthew talks about the picture of the skyscrapers that the state of Oklahoma put in its brief, I think really the far more important and telling story is how the Creeks came to be in a new homeland that was promised to them as their new reservation after all the sufferings they endured, and how they sought to carry on their old way of life in a new place. And that is the story of how really the Murphy and the McGirt cases start, with a promise from the United States that the Creeks would enjoy a new reservation, a treaty-protected reservation, and a story that never involved any legal disestablishment of that reservation. No treaty or statute after 1866 sought to diminish the bounds of the Creek Reservation, and sort of black letter reservation law that you need an express indication of intent from Congress to diminish a reservation before the court will find that. And that's really, this case puts that to the test, because what we ended up having in Oklahoma with the Creek Nation, and I think this is the story for the other 5 tribes as well, the other 4 tribes that were removed to eastern Oklahoma, is a situation where over time you had the force of demographics, the advent of statehood, the discovery of oil, a lot of factors all sort of acting in confluence at the turn of the 20th century to lead to a massive influx of settlers into what were these treaty promised reservations, and everything that followed, but never an act of Congress to disestablish reservations. And the question in the case ultimately boiling down now to, well, how will the court balance those 2 things, the law, the promises that were made, and the absence of any abrogation of those promises, against the sort of modern day demographics and pictures of skyscrapers and all the sort of horror stories that are told about, well, what would happen if the court reaffirms that this is Indian country. So in some ways you can view McGirt and Murphy as, reservation boundary cases. In some ways you can view them as cases about the history of Oklahoma, but really, like so many of our cases in Indian country, they ultimately boil down to the question of whether the courts will honor the law, honor promises made to Indian nations, or whether they will give away to factors of modern day convenience. And that is so often the balance that we see in Indian law cases, and one where the court honestly swings back and forth somewhere in that spectrum of fidelity to the law versus accommodation of current day concerns and fears. That's the first part of the story. The second story I want to tell, and I especially want to tell this because I believe we have an audience that has a lot of law students. It's a story I like to tell a lot. How did we get involved in this case? How did this case come to be? In about 7 or 8 years ago, we had a young law student, a recent graduate of law school named Philip Tinker, join our firm. Philip had gone to the University of Tulsa and had then done a clerkship on the 8th Circuit, and then came to our firm. When he was at the University of Tulsa Law School, he had written his law student note on the question of whether reservations continue to exist in eastern Oklahoma. And against the force of a lot of sort of conventional wisdom and conventional understanding, Philip had said, look, demographics, et cetera, being what they are, there's never been an act of Congress or a treaty that has abrogated these treaty promise reservations. They continue to exist. And while he was in law school, he had begun working with a group of public defenders who were seeking to defend the life of one Patrick Murphy. And they sort of with Philip as their informal Indian law advisor, had included in the arguments they were making to get Mr. Murphy off of death row the notion that the crime he had been convicted of committing had taken place on the Creek Nation reservation, and that therefore only the federal government had the authority, or the nation itself had the authority to prosecute him, not the state of Oklahoma. They had lost that argument on habeas in the district court at the time when Philip joined our firm. The case was pending in the 10th Circuit, and Philip came into my office the first day that he joined the firm and said, hey, I've been working on this matter. Could we continue to work on it, sort of pro bono? And I said, well, tell me about the case. And he told me it's this horrible, grisly murder. And the legal issue is whether the reservations continue to exist in eastern Oklahoma. And I looked at him and I said, no way, no way in the world are we going to take this case. These are like horrible facts, bad facts, make bad law. There's so much conventional wisdom about the Oklahoma reservations. We need a really good case with good facts if we're ever going to make that argument. But Philip's a very persistent fellow, and this case was in procedural limbo in the circuit. So for the next 2 years, he was literally in my office once a week saying, we got to take this case, we got to do it. And finally came in and said, look, this was when the case got out of limbo. Mr. Murphy's going to raise the argument, regardless of whether the Creek Nation gets involved, he's raising the argument. So don't you think the nation should get in and make the argument itself? And at that point I said, yes, you're right. If the argument's going to be teed up no matter what, this, directly implicates Creek Nation history and the law. So yes, we should. And that's how we came to be involved in the case. And I like to tell that story because I think it exemplifies that no matter how early you are in your career as a lawyer, and in fact, even as a law student, if you have the initiative and the creativity and the drive, you can make a huge difference. And so it's wonderful that all of you are interested in the field of Indian law, and it's a field where, I don't want you to ever think that, oh, I'm too young to advance this idea, or, these people with the gray hair or the gray beards, they know what they're talking about, and I need to wait my time. Absolutely do not. What can often make the biggest differences are people who are young and with a ton of energy and creativity, taking a fresh look and pushing us graybeards to advance arguments. So that's how we came to be involved in the case. And honestly, when the 10th Circuit issued its decision holding that the nation's reservation remained extant, it was one of the sort of greatest, happiest days in practice for all of us in our firm, because it really did come as I think a real watershed moment for a lot of people in Indian country who didn't think that those reservations continue to exist. The happiness in that moment was tempered by the reality that we pretty much knew the Supreme Court was going to take that case. It was just too important a case, and the state was pounding its chest too strongly about the potential consequences of a decision for the court to stay away. And so, thence began our sort of strange saga in the Supreme Court, where we have now gone through essentially 2 cases, 2 full sets of briefing, 2 arguments to have this question answered as to whether the nation's reservation continues to exist. It's been a long saga, but it's really in some ways been the thrill of a professional lifetime to be waging this battle, such a pitched battle in the court on such an important set of issues. I'll say just a couple of quick comments about the course of the last couple of years, and then, as I say, really want to open this back up to questions and thoughts. A couple of things. One is, it is a very, I think, important and telling fact that the court, which is often not, that, as we all know, has not been that sympathetic to tribal viewpoints over the years. The court has really let the Creek Nation speak with its own voice in this case, because of the procedural posture of the case. Both, first Mr. Murphy and then Mr. McGirt were the actual parties to the case. And it so often happens in Indian law, you have, these criminal defendants raising issues which are of fundamental importance to the tribes, but the tribes aren't parties to the case, and that can often be very frustrating. But both the 10th Circuit and the Supreme Court really let the Creek Nation speak with its own voice in these cases. We were essentially given full briefing rights and then the opportunity to argue, and that's been, I think, a very welcome development, and hopefully will set a bit of a precedent for the court to, continue allowing tribes to participate as full-fledged participants, even when they technically only have amicus status. Secondly, the cases have been procedurally somewhat irregular. Nothing has been that normal about them. In Murphy, we had the argument, and you sort of get through the briefing and the argument, and then you think, okay, we're done, and now we wait. And then the court ordered supplemental briefing showing that it was really grappling with some of the issues in the case. And we did a supplemental briefing. Then, of course, as everyone knows, sort of got to the end of the last term and waiting anxiously for a decision. And then the court ordered re-argument, which brought us into McGirt and allowed Justice Gorsuch to come into the case. And then this year, of course, we've had these sort of strange set of circumstances, which led us to ultimately have a phone argument with this new format that the court used, which was really quite interesting. And now we are back to waiting for a decision. And I can certainly talk about the experience of the argument and some predictions, but would like to stop talking, pause at this point, and see what sort of questions and thoughts and where we should go in the direction of the discussion.
Great, thank you so much. I'm going to take the moderator's prerogative and ask a burning question that I have, and then I'm going to turn it over to others. There's sort of several layers of questions kind of packed into this question, so however you and Matthew want to answer them in part or in full is up to you. But I'm really curious, and obviously I'm from Oklahoma, and I'm from an Oklahoma tribe too. I grew up in the southwest part of the state, which was the Kiowa Comanche Apache Reservation at a certain point. And of course, that also was allotted out. And I'm Potawatomi from, just east of Oklahoma City, and we also have our treaty territory there too. So I have a, vested interest in this in a lot of different ways. I'm really curious, when we kind of when we think about the justices and we think about their political leanings and their prior opinions, both in Indian law and in other fields, I'm really interested to sort of think about how both strict textualism and plenary power will play in a case like this. You could imagine, for example, that this, the relatively conservative, I guess, idea that the United States is the imperial power, and that plenary authority has to come from Congress. And in its absence, the reservations were not disestablished. And if you look at the, as you all showed in the case, that's what the record demonstrates, balanced against things like the actual state of things. And it makes me think, of course, of Ginsburg's opinion in Sherrill, changing demographics and fairness to non-Indians and those other kinds of things that come in, even from the liberal side of the court. So I'm just really curious how you think those things might be weighed in and how it went in oral argument in terms of what you think the justices were focused on. And I guess the related question to that is, I'm wondering if you think that this case will be answered with legislation. I know that there's an argument to be made that all 5 of the 5 civilized tribes are similarly situated or might be. I guess I have a question about how many other tribes in Oklahoma might have arguments, especially given that, most of us had treaty-based reservations that were also allotted. So I guess that's kind of a mix of related questions, but I'm curious if you guys could respond to some of those questions and ideas.
Well, I can certainly, those are great questions, and I can certainly say a few things. I'm sure Matthew has more insightful things to add. But on the first part about judicial philosophies and how they might relate to this case. Of course, here we're operating in the absence of a decision, and so none of this is meant to be predictive, but just sort of observational. In a lot of ways, I would say that Justice Gorsuch was our perfect justice for this case, for our side of the case, because so many of the strains of his judicial philosophy point in the same direction, and we hope in the direction of a ruling in favor of the existence of the reservation. But textualism, and of course on the court now they say they're all textualists, but I think there are varying degrees of fidelity to the text when it comes to Indian law cases. But Justice Gorsuch is a strong textualist, and I think he is someone who is very principled in that regard. And his textualism here would point, as it should, and as the court said in Parker, in favor of saying, well, Congress has never spoken to the disestablishment of these Eastern Oklahoma reservations, and it's Congress's job. And that's sort of the second strain of his philosophy, which is being a very strong believer in the separation of powers. And as you said, Angela, if for those who, it's sort of kind of the accepted understanding at this point, Congress has this plenary power. It's up to Congress to disestablish reservations or take other, measures in our field of law. And where we've seen a lot of the worst Supreme Court decisions over the last 20 or 30 years, they've been decisions where the court has gone beyond that strict understanding of the separation of powers to say, well, Congress may not have acted, but the result here would be so untenable, so inconsistent with our notion of tribes as these, domestic dependents, as inferior, this whole notion of the implicit divestiture powers, that we're going to divest the tribes of powers, even where Congress hasn't spoken to that. That's been a strong strain in the court's jurisprudence. And you mentioned the Sherrill opinion. I think Sherrill is sort of one of the big exemplars of that approach. And Justice Ginsburg's opinion there, that is someone where a strong believer in the separation of powers like Justice Gorsuch, I just don't think would go there. And so again, in our case, where there is no clear evidence of congressional intent to disestablish, that speaks, I think pretty strongly to him. And then third component of his philosophy, which I think is shared by others on the court, like Justice Kagan, Justice Sotomayor, sort of an understanding that tribes aren't these bogeymen, that tribes can continue to exert authority in our modern world, in our sort of federalist system, in a way that is actually beneficial, not detrimental to those who are in Indian country, not only tribal members, but non-citizens. I think Justice Gorsuch has an understanding of that. Some of the other justices do. And so all those factors for a justice like him would point in the favor of finding the reservation still to continue to exist. Whereas some of the other justices who may profess a fidelity to textualism might, however, be more scared by or concerned about these sort of, practical ramifications. So especially in the first argument in Murphy, we got a lot of questions about, well, if the tribe wins, then, what about X, Y, or Z practical factor? With the Chief Justice, going so far as to say, well, I know what we held in Parker, but that involved, this small town of Pender, and Tulsa isn't Pender. And that was really something that we found to be a somewhat striking / shocking question, because it was almost effectively saying, hey, look, the results matter here. The practical implications could override sort of an even-handed application of the law across reservations and across different parts of Indian country. And so that was sort of far more concerning. I'll pause there, see if Matthew, you want to add anything, and then can talk a little bit about the legislation issue.
Yeah, I'll go. Everything that, Riyaz said about textualism and separation of powers, I completely agree with. There's another aspect to this case that is, I think, related to what Riyaz was saying earlier about having the opportunity to have the tribe speak with its own voice, to argue the case, to be given full briefing authority. and opportunities. And this tribe is unusual in the United States in that it's relatively successful. It's a large tribe. It's not a small tribe. This reservation, and that's why this reservation in part is so large to begin with, territorial wise. It has resources. And it's also in a state that I've talked about this case a lot, not so much in such a big group, but I would say this is a failed state of the United States. Oklahoma its legislature is effectively bought and sold by the energy extraction industry. And there is not a lot of good governance going on in the state of Oklahoma. And if there is effective government in Oklahoma, it's from tribes like Muskogee Creek Nation. Now, it's not true entirely in every single jurisdiction in Oklahoma, but the state of Oklahoma is kind of like functionally bankrupt, and really has relatively speaking, limited resources, like many states. Well, I won't get into politics, but it just is. And the briefing from Muskogee and some of the tribes talking about what the Muskogee Creek Nation has done to enhance really the quality of life of people within its reservation, both tribal members and non-tribal members, is a really very powerful statement. And I'm not sure if very many justices on the court will give it the kind of credit it is due. It is a statement that, to the heart of it, goes to the failure in some ways of federalism. The United States has vacated the field of Oklahoma a long time ago when it came to Indian affairs. And the state of Oklahoma isn't doing all that well either. I mean, the whole place is just racked with earthquakes all the time that never used to happen. And you have these tribes that are taking the welfare state seriously. They're also part mostly of the extraction and energy extraction industry as well, where a lot of those resources come from, but they also take their homelands seriously in terms of environmental regulation and pollution control. And so it seems like, if you read the briefs, Oklahoma is saying we're going to lose everything if you rule in favor of these two guys in our jails, and the tribe is saying, we have stepped up in a way that Oklahoma hasn't, and I think that kind of argument, I think, is really quite wonderful, but also for the court is a little bit terrifying, because that kind of argument can be replicated with some of the other tribes around the country. You see that a little bit here and there in Michigan, like the Potawatomi tribes in Southwest Michigan are incredibly successful at governing, even with their way, way smaller land bases, in an area of Michigan that has historically been a post-industrial wasteland. And there are other places around the country where you see this here and there as well. And I really like to see those kinds of cases at the court. It makes the court think a little bit. But I'm also terrified of how the court is going to react to that, because when they look at the facts on the ground as presented to them in a case like this, and then they go back and read the federal government, the United States Constitution, which is there designed to protect the federal and state interests, and tribal interests are excluded from protection in the Constitution for the most part, it's confounding to them. And I don't think they really know what to do with those kinds of ideas. It's always easier to rely on what you know, which is go back to Hart and Wexler in federal courts and federal jurisdiction, and just or Chemerinsky even in constitutional law, and just defer to the federal and state government. The United States here in this case, I want to also make one last point, has really just completely botched the briefing in this case. It is articulating a position, a narrative that is completely antithetical to the facts on the ground. And I mean, it's doing so in a way that I don't think is actually, in this case, I originally did. I thought it was very political, but I don't think it's political. I think it's a position that the United States has taken for a long time in relation to Oklahoma that it never should have taken. It's a failure of the duty of protection, the trust responsibility to Indian tribes, but also I think it is a failure to the court. The Department of Justice right now is under a lot of fire for making lots of misrepresentations to the court over the last 10 years, and Indian law is no exception to that. And that's not going to really come up in any of this, but I wanted to point that out in part because, we haven't talked about the United States in this case. They're in every single Indian law case. They get to argue too. And they've strongly sided with Oklahoma in this case, which is not beneficial to the tribe. It's not surprising either, but it's concerning. And I also think it is contrary to what the reality is on the ground, at least on this reservation in Oklahoma.
Thank you, Matthew, and both of you for those insights. I don't know if you want to tackle the possibility of legislation question or not, or we could go to the chat queue, because I know that there are some other questions out there. So I'll defer to you on that.
Well, I'll say quickly about the legislation, and then I think there's at least one question in the chat queue that ties in nicely to what Matthew was just talking about, which I'd like to address. But on the legislation front, one thing that really, we had never done a case in Oklahoma until Murphy, and so it's been a tremendous education for me. And one of the things that really struck me is just how much interaction there is between the nations there and the state government and members of Congress, and there's just an incredible amount of overlap and interaction that you don't see in a lot of parts of the country. So there's been very active interest in the case from various members of the congressional delegation in Oklahoma, and one of the sort of really unusual things about the case, in a very positive way, is we had this amicus brief in both cases filed on behalf of the nation by this sort of assortment of former Oklahoma state officials, including former governors and members of the House and Senate and state legislators. And the principal signatory on that brief was Congressman Cole, who is still in Congress, one of the highest ranking members of Congress on the Republican side, very strong advocate for and interest in Indian affairs. And here he is joining this brief that is a very strong brief that talks about some of what Matthew was discussing, just how important the nations are in Oklahoma to governance and to the betterment of the lives of both Indians and non-Indians throughout the state. So I think there is a very strong interest, Angela, in the case on the part of the congressional delegation. And I think what that might translate into, I don't think we're in a world anymore where you would ever have Congress, disestablish a reservation in the face of a positive court ruling. I don't think we're at any risk of that. But I do think that if the court were to affirm the existence of the reservation, that there might be practical issues that the nations, the state, and members of Congress want to look at and see whether they might address legislatively. There's an incredible amount of Oklahoma-specific legislation dealing with with all manner of issues. And given the strong working relationships there, I don't think that would be a surprising development.
Great, thank you so much. I'm going to turn it over to Lauren to take us to some of the chat questions. Thanks, Lauren.
Yeah, we have a couple questions, and I think I might tackle them in reverse order just based on our conversation. Ian's asking that despite the Oklahoma-centric nature of this case, could you comment on the political impacts that this might have for Indian country outside of Oklahoma?
Yes, I think the most important thing is that, obviously the details of the case involve Oklahoma history and Oklahoma specific facts. But ultimately, I think this case, to tie back to what I said at the outset, it tests whether the court is going to adhere to its decision in Parker. The 2015 decision in Parker was essentially a decision where the court said, even though we've sort of been trending in this direction of looking at demographics and present on the day reality, that's those factors that sort of become very important to the court's disestablishment jurisprudence. That's not where we should be. Really, we're looking at congressional intent, and that means the text, And if there's compelling evidence in the surrounding circumstances, we'll pay attention to that. But those, sort of first two prongs of the so-called solemn test, that's where we should be directing our focus. And it was, when Philip Tinker was coming to my office and trying to convince me that, there was a prayer in this case, the other really important thing was that's when the Parker decision came down. And that was such a strong statement by the court that we're going to return to more normal modes of statutory interpretation and principles of Indian law, that it gave, I think, hope for these reservation cases where previously I think a lot of us have been somewhat fatalistic. And so this case, I think, is really going to test the court's commitment to what it said in Parker. And in the face of, very strong demographics and pictures of skyscrapers and all this fear-mongering, are we nevertheless going to adhere to what we said there about the importance and primacy of the text?
I think that on, more esoteric professorial level, it seems like just in the last decade, maybe less, maybe since the confirmation of Sonia Sotomayor, the court seems more vested in Indian law cases. That doesn't mean they're going to take more, but they're more, the points are more disputed than they once were. You would see opinions like, well, I'm going back too far, but, the Oliphant case, somebody should have done some very basic typesetting and editing kind of things with Oliphant. And you had a dissent that was, two judges who basically wrote about a paragraph and a half and then just said, you're going to lose. They shouldn't, but whatever. And I think you're seeing, I suspect, I really don't know, you're seeing a lot more time and energy spent in thinking about in contesting a lot of issues, in contesting the ground of how Indian law cases are decided. And after I heard oral argument in this case, this is the first time we've ever got a chance to hear Clarence Thomas speak in an Indian law case, as far as I can tell, for at least a few decades. And it was really important, I think, because he's the second, the oldest, the longest serving justice on the court. So he was after the Chief Justice, the second person to ask the questions. It was sad to hear him, sort of poo-poo his own decision in Parker and say, oh, I'm going to backtrack on that. Seemed to be the implication. Maybe you can put a nicer salve on it than I can. But it really framed the case as more of a textualist-based case than what was going on, I think, in the Murphy case. And maybe also because Justice Gorsuch wasn't participating in the Murphy argument. But I also saw just so many widely varying points of view in how this case is to be framed and decided that I really don't know that we will have a majority. It's possible we won't have a majority opinion in this case. I don't know how we saw this in the Cougar Den case, and I wonder if that's going to be an ongoing trend. We've had a couple of cases that have been decided 4-4. Murphy seems to be a third case that potentially was 4-4. They seem really split on very fundamental Indian law issues and how these cases are framed. And I think part of that, and I'm not blaming Justice Sotomayor, but she has expressed a lot of positions in concurring opinions that she didn't have to do, that before her were rarely expressed, relatively speaking. Nevada versus Six is a really good, glaring exception that perhaps proves the rule that I'm trying to show. For cases going forward, I would not, even if the tribe wins here and the court just says, look, the part of Solemn versus Bartlett, the reservation boundaries, the extinguishment test that we've applied, with their third part of that, which is all about demographics and disruption, and it's basically a prototype of what the Sherrill opinion is. Maybe they get rid of that or poo-poo it to the point, or diminish it to the point that it's nothing. That's great. But I really do think that the court is paying a lot of attention to Indian law cases, and they should be, in part because of tribes like Muskogee Creek Nation that are really huge economic players, political players in large swaths of Oklahoma. Many of the biggest tribes, the 5 civilized so-called tribes, are really powerful political interests. And, they have an outsized impact compared to certainly just a few decades ago, a half century ago, when those tribes were still under the thumb of the federal government. They've done things that are really quite remarkable, that I think are shocking to people in Oklahoma who make big policy choices, who are used to making policy choices without upsetting a beast like these large tribes, these powerful tribes. So, when I look at these cases, I think it's just another reservation boundaries case. And poor Murphy and poor McGirt, they're not poor, both of them are horrific criminals. But, I just was thinking that the law isn't going to really shift. It was my initial impression, but now I don't know. I think they can go in all sorts of different directions. And that's my ultimate point, is that the court has always been so unpredictable in Indian law. You never know when you're going to get an opinion, from an opinion like Cheryl, from a justice like RBG, who can completely rewrite Indian law, and all they need to do that is 5 votes. And that's still the case. And I think it's more so now than ever before, because there are so many amici out there who can say whatever they want. And now we can have states like Oklahoma who can say whatever they want as well. Don't go to the Supreme Court is all I'm saying. Unless you're on death row and you got no choice.
But even then, we're going to have quite a few amici saying whatever they want. Riyaz, Matthew entertained a little bit of a prediction, which was sort of a non-prediction about where this might go. Do you have any thoughts about what we might see in a written opinion?
So, I'm far too superstitious to make any actual predictions, and also fully agree with what Matthew said, which is it's a fool's errand to predict how the court may go in Indian law cases, because sometimes we get some real surprises and shockers. What I will say is this, and I think it's important for people to keep in mind, is very clear coming out of McGirt, our sort of overriding feeling was, while we think of this as a disestablishment case, there really are probably at least 3 possible outcomes here. One is that they find the reservation, disestablished, heaven forfend. 2 is that they affirm the existence of the reservation. But a third possibility, which some of the justices questioning was really strongly getting at, was that they might find that criminal jurisdiction was transferred by virtue of these early turn of the century statutes to the state of Oklahoma, and such that Mr. McGirt and Mr. Murphy would lose, but the court might, in saying that, then not actually even reach the reservation question, just leave that for another day, or might conceivably reach the reservation question, find the reservation to still exist, but find jurisdiction to have transferred over. So it's very hard. There are definitely a number of permutations, some of which we'd be extremely happy about, some of which would sort of fall into the category of, well, we live to fight another day, and the saga continues. And then of course the worst case scenario would be disestablishment, and it's very hard to say from the McGirt argument. There clearly were some strong currents and cross currents, and justices like Justice Breyer and Justice Ginsburg, who I did not hear in this case sort of expressing strong support for a disestablishment holding, at the same time clearly expressed concerns about present-day criminal consequences of a reservation affirmation finding. So that path of saying that criminal jurisdiction was transferred over, that may have some potential appeal for them. And if I might add one comment about the court more generally, in part in response to what Matthew said. For years and years, and this is really why the Tribal Supreme Court Project was founded, we had a very strong concern about cases reaching the court, and the playbook for tribal advocates was really, try to win cases in the circuit courts and then try as hard as possible to keep those cases out of the Supreme Court, right? That was really our playbook, and a tremendous amount of time and energy invested in cert oppositions and in convincing tribes not to tee up cases that the court might really then use to wreak a lot of damage. For those on this luncheon who are students, I would say you are getting into the field at a better, more promising time, and really, for the first time in my career, which is like a 25-year career at this point, first time feeling sort of hopeful and optimistic that we may actually be able to advance the ball in the court on some issues and be more proactive rather than simply defensive. And that does have a great deal to do with what Matthew talked about in terms of the changes in composition of the court. And I think there have been 3 key additions in the last decade. Justice Sotomayor, who Matthew mentioned, and Justice Kagan both have a very strong interest in Indian law and are willing to really dig deep and have written some opinions, I think, that sort of harken back to some important first principles of the sort that Professor Riley was talking about. And then Justice Gorsuch, who we've discussed, who was our first Westerner addition to the court in a long time, who clearly has a lot of pride in being a Westerner and in having an understanding of tribal sovereignty and of some of the on the ground realities of reservations. So the 3 of them are bringing sort of an energy to the court's consideration of Indian law cases that does, I think, portend some hope for the future.
Great. Thank you so much for that. I think we have 1 minute left. Matthew, do you have anything you want to close us with before we wrap up?
No, I just responded to a question on chat. I think that the question is another possible impact if the court says some nice things about the fact that Muscogee Creek Nation has really stepped up its governance capability. That could extend. That kind of analysis is useful for other types of cases. Kind of along the lines of like when Justice Kagan in the Bay Mill case wrote about how tribes don't have a tax, or actually Justice Sotomayor in particular wrote about in the Bay Mills case about how tribes don't have a tax base and that's why they need economic development to pay for government services. That's the kind of thing you like to see in a Supreme Court opinion that can translate to good optics and utility in other cases.
Can I just add on that note? I don't want to keep us over time, but I think that's such an important point, and it goes to some of the questions that have been raised on the chat. But I think one of the fundamental, there's a saying that I like that I think is fundamental to litigation, which is, if you don't tell your own story, somebody else will tell it for you. And I think it's so important for tribes to tell their story in front of these courts who don't necessarily have the greatest on the ground understanding of what tribes are doing or appreciation of the power of tribal sovereignty, just how much good governance they are engaged in. And so one of the questions was, well, how do you deal with this, all the fear mongering? And in some ways, I think the best way to deal with that is to say, look, here's what's actually happening. Here's what tribes are doing. And Oklahoma and the Creek Nation was such a wonderful opportunity for us to tell that story, because there was so much good, sophisticated governance going on, especially in comparison to the surrounding governments. And the more that all of us in this field can tell that story, whether we're litigators or whether we're working for tribes and structuring their government, the more the predicate can be laid, the stronger the story can be told, the better off we'll all be in the courts.
Well, I want to be respectful of your time. Thank you both so much. It's really an honor and a pleasure to have you on here speaking to us and to speaking to this audience. You both are incredible advocates for Indian tribes and for Indian country, and my deep gratitude to you both, and for taking time out of your busy schedules to do this. So thank you very much. Thank you, Lauren, for organizing this, our wonderful clinic director, and Heather, our administrative staff. hope you guys are all well, and hopefully we'll continue this conversation in another way, maybe in person at some point when this opinion is down. So take care, everybody. Thank you.
Thank you.